of misconduct, and the same is true of 6 prior FBI investigations conducted during Judge Kavanaugh's 25 years of public service. Nothing an investigator, including career FBI special agents, does ever be good enough to satisfy Democrat leaderships in Washington who staked out opposition to Judge Kavanaugh before he was even nominated. There is simply no reason then to deny Judge Kavanaugh a seat on the Supreme Court on the basis of the evidence presented to us. The Democratic strategy used against Judge Kavanaugh has made one thing clear: they will never be satisfied, no matter how fair and thorough the process is. 31 years ago, the Senate Democrats' treatment of Robert Bork, their playbook remains the same. For the left wing, advice and consent has become search and destroy, a demolition derby. I'm pleased to support Judge Kavanaugh's confirmation. I'm sorry for what the whole family went through the last several weeks. We should all admire Kavanaugh's willingness to serve his country despite the way he's been treated. It would be a travesty then if the Senate did not confirm the most qualified nomination in our nation's history. The multitude of allegations against him have proven to be false. They've also proven that no discussion of his qualifications came up with any discussion of his qualifications. Nothing showed he wasn't qualified. We had a campaign of distraction from his outstanding qualifications, a campaign of destruction of this fine individual. What we have learned is the resistance that has existed since the day after the November 16, 2016 election is centered right here on Capitol Hill. They have encouraged mob rule. When you hear things about get in their face, bother people at every restaurant where you can find a cabinet member, these are coming from public service that ought to set an example of civility in American society. And it's been made worse by what has happened to Judge Kavanaugh. I hope we can say no to mob rule by voting to confirm Judge Kavanaugh. I yield the floor.
Madam President.
Senator from California.
Madam President, I understand that in the order I have 15 minutes. Is that correct?
The senators recognize.
Thank you very much. Mr. President, Madam President, this has been my 9th Supreme Court nomination hearing, and I must say, I've never experienced anything like this. Never before have we had a Supreme Court nominee where over 90% of his record has been hidden from the public and the Senate. Never before have we had a nominee display such flagrant partisanship and open hostility at a hearing. And never before have we had a nominee facing allegations of sexual assault. The nominee before us, being considered for a pivotal swing seat, if confirmed, would be the deciding vote on some of the most important and divisive issues of our day. I'd like to start by speaking about some of the issues in relationship to Judge Kavanaugh. President Trump promised to only nominate individuals to the Supreme Court who would be pro-life and pro-gun nominees, who would automatically overturn Roe v. Wade. In my judgment, Judge Kavanaugh clearly meets the test. In a speech in 2017, Judge Kavanaugh focused on praising Justice Rehnquist and his dissent in Roe v. Wade, where he challenged the right to women's privacy as protected in the Constitution. Also last year, Judge Kavanaugh argued in a dissent in a Texas case that a Jane Doe should not be able to exercise her right to choose because she did not have family and friends help her make the decision. If adopted, This argument could rewrite Supreme Court precedent and require courts to determine whether a young woman had a sufficient support network when making her decision, even in cases, as is in this one, where she had gone before a court. His reasoning demonstrates that Judge Kavanaugh not only is willing to disregard precedent, but his opinions fail to appreciate the challenging realities women face when making these most difficult decisions. When I asked him about whether Roe and Casey were settled law and whether they were correctly decided, he refused to answer. He would only say these cases are entitled to respect. Roe v. Wade, as we all know, is one of a series of cases that upheld an individual's right to decide who to marry, where to send your children to school, what kind of medical care you can receive at the end of life, as well as whether and when to have a family. The government cannot interfere with these decisions according to these cases. Another issue that gives me great pause is Judge Kavanaugh's extreme view on guns. In reviewing his record and judicial opinions, it's clear his views go well beyond simply being pro-gun. During a lecture at Notre Dame Law School, Judge Kavanaugh himself said he'd be, quote, the first to acknowledge that most lower court judges have disagreed with his views on the Second Amendment. Specifically, in District of Columbia v. Heller, Judge Kavanaugh wrote in a dissenting opinion that unless guns were regulated, either at the time of the Constitution was written or traditionally throughout history, they cannot be regulated now, end quote. In his own words, gun laws are unconstitutional unless they are, quote, traditional or common in the United States, end quote. Judge Kavanaugh would have struck down D.C.'s assault weapons ban because they have not historically been banned. This logic means that as weapons become more advanced and more dangerous, they cannot be regulated at all. When I asked Judge Kavanaugh about his views that if a gun is in common use, it cannot be regulated, he replied this way, and I quote, "There are millions and millions and millions of semi-automatic rifles that are possessed, so that seemed to fit common use and not being a dangerous and unusual weapon," end quote. Think about that. Judge Kavanaugh made up a new standard that had nothing to do with common use, but instead relied on whether a gun is widely possessed and owned as determinative as to whether it is subject to any regulation. The United States makes up 4% of the worldwide population, but we own 42% of the world's guns. By Judge Kavanaugh's standard, no state or locality will be able to place any limitation on guns because of widespread ownership in this country. I'm also concerned about his views on presidential power. Specifically, he has said that sitting presidents cannot be indicted, cannot be prosecuted, should not be investigated, and should have the authority to fire a special counsel at will. In other words, the President of the United States is above and outside the law. These views raise serious concerns that should concern us all, especially at a time when the President continually threatens to fire the leadership of the Department of Justice for failing to be loyal and reining in the Mueller investigation. These views alone are not sufficient for me to vote against Judge Kavanaugh, but what we have seen and experienced in the past several weeks has raised serious new concerns, concerns I believe should worry us all. Judges are expected to be, quote, even-handed, unbiased, impartial, and courteous, end quote. However, at the hearing last week, we saw a man filled with anger and aggression. Judge Kavanaugh raised his voice, he interrupted senators, he accused of Democrats of, quote, lying in wait, end quote, and replacing, quote, advice and consent with search and destroy, end quote. He even went so far as to say that Dr. Ford's allegations were nothing more than, quote, a calculated and orchestrated political hit, fueled with pent-up anger about President Trump and the 2016 election, end quote. Quote, revenge on behalf of the Clintons, end quote. How could he? This behavior revealed a hostility and belligerence that is unbecoming of someone seeking to be elevated to the United States Supreme Court. His display was so shocking that more than 2,400 law professors from around the country have expressed their opposition. They wrote, and I quote, instead of trying to sort out with reason and care the allegations that were raised, Judge Kavanaugh responded in an intemperate, inflammatory, and partial manner as he interrupted and at times was discourteous to senators, end quote. The professors concluded, and I quote, we have differing views about other qualifications of Judge Kavanaugh, but we are united as professors of law and scholars of judicial institutions in believing he did not display the impartiality and judicial temperament requisite to sit on the highest court of our land. Madam President, I ask unanimous consent to enter a full copy of the letter in the record.
Without objection.
Thank you. Finally, I want to mention the serious and credible allegations raised by Dr. Christine Blasey Ford and Deborah Ramirez, the two women who came forward to tell their experiences facing sexual assault. When Dr. Ford decided to make her story public, she faced all her worst fears. She was harassed, she received death threats, she had to relocate her home, her husband, and 2 children, and yet, in less than a week, she came before the Senate and told 21 senators she had never met, along with millions of Americans, about the most tragic, traumatic, and difficult experience of her life. And she did so with poise, grace, and most importantly, bravery. Unfortunately, she was met with partisanship and hostility. My Republican colleagues have largely chosen to ignore her powerful testimony. Senators weren't allowed to hear from any witnesses who could corroborate or refute her account. They refused to gather evidence or do an impartial investigation into her allegations. Deborah Ramirez also reluctantly came forward to tell her story. Like Dr. Ford, Ms. Ramirez offered to speak to the FBI. Both Ford and Ramirez submitted evidence to support their allegations, including naming over 24 witnesses each. Unfortunately, the limited investigation that was conducted by the FBI failed to interview any one of the witnesses these 2 women identified who could support her account. Let me say that again. They refused to investigate, to talk with any of the 24 witnesses that could have supported their accounts. Mr. President, I think it's important to remember why we're here today. We're here to determine whether Judge Kavanaugh has demonstrated the impartiality, the temperament, the even-handedness that's needed to serve on this great high court of our land. If confirmed, he will join 8 other individuals who are charged with deciding how the laws of our land are interpreted and applied. He would be a deciding vote on the most important issues affecting our country and every American for generations to come. Mr. President, Madam President, based on all the factors we have before us, I do not believe Judge Kavanaugh has earned this seat. Thank you.
Madam President.
Democrat leader.
Thank you, Madam President. Now, Madam President, from start to finish, President Trump's nomination of Judge Brett Kavanaugh to the United States Supreme Court will go down as one of the saddest, most sordid chapters in the long history of the federal judiciary. The well was poisoned from the outset when President Trump selected Judge Kavanaugh from a list of names pre-approved by hard-right special interest groups for whom the national interest is a trifling concern compared to repealing Roe v. Wade, cutting people's health care, and achieving a partisan majority on the Supreme Court. The rot worsened when the Republican majority on the Judiciary Committee shielded the bulk of Judge Kavanaugh's records from the public, discarding decades of bipartisan precedent and thwarting norms of transparency and of fairness. And finally, the dam broke under the weight of credible allegations that Judge Kavanaugh committed a sexual assault in high school. In 2018, the Republican majority conducted a hearing that made the Anita Hill hearings in 1991 look fair by comparison. In this hearing, there were no corroborating witnesses on either side, no independent investigation of the facts to inform the questioning. They even hired an outside counsel to put a witness, Dr. Ford, on trial. Only at the 11th hour, urging of breakaway members of their caucus, Republicans submitted reluctantly to a one-week investigation of the allegations, an investigation which was then severely circumscribed by the White House. Our Republican friends blame us for this process. They're always finding a straw man, but nothing could be further from the truth. First, they blame us for delay, knowing full well that Majority Leader McConnell has complete control of when nominees are brought to the floor. Leader McConnell could have moved this nominee 2 weeks ago or 1 week ago. Democrats had no say, and don't, when it comes to who comes to the floor. But in each case, Leader McConnell couldn't move the nominee forward because he was blocked by fellow Republicans, not Democrats, from moving forward. When it comes to complaining about delay, 2 words never come from our Republican friends' lips: Merrick Garland. Republicans are also saying we engaged in, quote, a smear campaign or the politics of personal destruction with this nomination. In reality, again, they're using Democrats as a straw man, because what they're really talking about is what Dr. Ford said. Democrats did not induce her to come forward. Her conscience did. And our Republican friends, are our Republican friends accusing Dr. Ford and her deeply held memories of what happened to her of a smear campaign? Are they accusing Dr. Ford of a smear campaign? Of engaging in the politics of personal destruction? Because that is who they're actually blaming. They're decrying her testimony and then trying to blame Democrats. I don't blame them. They have a flawed nominee. They don't want the focus on the nominee. When future Americans look back at these proceedings, let them draw no lessons from the Senate's conduct here. Let them look back on this chapter as the shameful culmination of the scorched earth politics practiced by the hard right in America. People who will stop at nothing to entrench an advantage on our nation's courts. Let the confirmation process for Judge Kavanaugh be recorded as a sorry epilogue to the brazen theft of Justice Scalia's seat, the ignominious end of bipartisan cooperation and consultation on the confirmation of Supreme Court justices. And for what? For whom were Senate Republican leaders willing to discard all semblance of fairness to confirm? Judge Brett Kavanaugh, certainly a product of an elite education, but also someone with hard right, conservative jurisprudence, far, far away from what average Americans believe. Why most Democrats opposed his nomination at the outset feels like ancient history now. But let us not forget that, most importantly, we strongly disagree with a number of Judge Kavanaugh's views. He's deeply skeptical of unenumerated rights, including a woman's right to make fundamentally private decisions about her medical care. He's deeply skeptical of the government's role in protecting Americans with pre-existing conditions. He's deeply skeptical of nearly all rules and regulations that protect consumers, workers, the environment. And the flashing red light warning sign at the center of Judge Kavanaugh's jurisprudence are his views on executive power and accountability. Somehow, this conservative judge and scholar of the Constitution sees at the heart of American democracy a president cum king, an executive who's unaccountable to the laws he's sworn to uphold, a head of state who, while in office, should be beyond the reach of subpoenas, criminal investigations, or civil investigations. This moment in American history demands deep skepticism about Judge Kavanaugh's views on executive power, nominated as he was by an executive who disdains the constraints of his office and who is at this very moment the apparent subject of investigations his Supreme Court nominee believes should be invalid. I met with Judge Kavanaugh for almost 2 hours, and I asked him about all of those issues. His answers were constantly evasive and utterly unsatisfactory. It was deja vu all over again in the first round of hearings, when Judge Kavanaugh deliberately avoided talking about his views on Roe, health care, presidential accountability, and more. There was no legal reason, rule, or logic that prevented him from being clear and saying what he thought. He was evasive because he knows that his views are deeply at odds with the progress America has made over the last century of jurisprudence, and at odds with what most Americans believe. His performance was not only unfair and frustrating to the Senate, it was unfair to the American people. When a nominee refuses to disclose their views, chances are you have a nominee whose views are far outside the mainstream of America, whether they be far right or far left. My colleagues on the other side of the aisle may not have as grave a concern about these views as we do, but let no American be surprised if Judge Kavanaugh becomes a decisive vote to restrict the rights and privileges of the American people while stretching the bounds of privilege for the current occupant of the White House. Judge Kavanaugh's nomination ultimately does not only encompass questions of ideology or credentials, but questions of character. Here again, Judge Kavanaugh falls woefully short of what Americans expect and deserve in a Supreme Court justice. He has repeatedly misled the Senate about his involvement in some of the most serious controversies of the Bush administration, including warrantless wiretapping of American citizens, our policy against torture, the theft of electronic records from Democratic senators, and his involvement in the nomination of very controversial judges. Faced with credible allegations of various types of misconduct, Judge Kavanaugh's credibility was again tested, and he continued to dissemble and even prevaricate about easily refuted facts. Beyond the issue of credibility, Judge Kavanaugh presented to the Senate the bitterest partisan testimony I have ever heard coming from a candidate seeking the Senate's approval, whether they be for the bench or the executive branch. Now, there are many who think that what happened when Judge Kavanaugh was 17 years old should not be dispositive. Even if you believe that, his actions at age 53, in terms of demeanor, partisanship, and above all, credibility, should be dispositive. Judges at every level of the federal bench should be held to the highest standard of ethics and moral character. Judges at every level should be judicious and credible and independent, but especially on the Supreme Court. I do not see how it's possible for my colleagues to say with perfect confidence that Judge Kavanaugh has the temperament, independence, and credibility to serve on the United States Supreme Court. So, I ask my colleagues on the other side of the aisle, why Judge Kavanaugh? There is no dictate that you have to march blindly forward with a nominee when there are others available to you. There are many judges who I'm sure conservatives would be happy to have on the court. I'd remind my colleagues, the seat that Brett Kavanaugh aspires to fill was held by a justice who assumed the bench after one nominee was voted down by the Senate and a second nominee withdrew his nomination. But the Republican majority has pressed forward blindly on Judge Kavanaugh, even when brave women came forward to speak truth to power. Why? For what cause? For the sake of winning? That's not reason enough. My colleagues on the other side, if you have doubts about Judge Kavanaugh's credibility, about his ability to tell the truth, about his ability to be impartial and nonpartisan, no matter what you think of his jurisprudence or what he may or may not have done in high school and college, you should not vote to confirm him to the Supreme Court. So, my friends, Democrat and Republican, for all the controversy, all the heavy-handedness of the process, all the hyperbole and vilification of both sides, there's always hope that the Senate can save itself. We can salvage some decency here at the end. If Judge Kavanaugh is rejected, President Trump will select another nominee, likely right of center, probably not to my liking, but without the cloud that hangs over this nominee. And we can proceed to consider that nominee in a much less bitter, much better, less partisan way. A bipartisan majority of senators, considering fully the weight of Judge Kavanaugh's testimony, record, credibility, trustworthiness, and temperament, considering fully the heartbreaking testimony of Dr. Christine Blasey Ford, can vote to reject Judge Kavanaugh's nomination and ask the President to send the Senate another name. For the sake of the Senate, of the Supreme Court, and of America, I hope, I pray, my colleagues will do so.
Madam President.
The Majority Leader.
It was 88 days ago that President Trump announced his nomination of Judge Brett Kavanaugh to fill the current vacancy on the Supreme Court. Judge Kavanaugh is a nominee of the very highest caliber, a brilliant legal mind, an accomplished jurist with a proven devotion to the rule of law. Today, the Senate has the opportunity to advance his nomination. Every one of us will go on record with one of the most consequential votes you ever cast in the Senate. Now, the stakes are always high for a Supreme Court nomination, but colleagues, the extraordinary events of recent weeks have raised them even higher this time. When we vote later this morning, we will not only be deciding whether to elevate a stunningly well-qualified judge to our highest court. Not anymore, not after all this. The United States Senate will also be making a statement. We'll either state that partisan politics can override the presumption of innocence, or we'll reaffirm that in the United States of America, everyone is innocent until proven guilty. We'll either state that facts and evidence can simply be brushed aside when politically inconvenient, and signal that media bullying and mob intimidation are valid tactics for shaping the Senate. The mob can attack, and the Senate caves. Or we'll stand up and say that serious, thoughtful, fact-based deliberation will still define this body. We'll either give notice that totally uncorroborated allegations are now officially enough to destroy an American's life, or we'll declare that our society cannot, must not, will not set the bar so low. So, Madam President, today is a pivotal day in the nomination process of this excellent judge. But it's a pivotal day for us here in the Senate as well. The ideals of justice that have served our nation so well for so long are on full display. So let's step back and sample a few of the choice moments that the Senate and the American people have been treated to during the disgraceful, absolutely disgraceful spectacle of the last 2 weeks. The very night Judge Kavanaugh was announced as the president's choice, we heard the junior senator from Oregon declare that this nominee would pave the way to tyranny. His audience? Crowds of far-left protesters, still filling in the blanks on their picket signs. They weren't quite sure who the nominee was going to be yet. We've heard the junior senator from New Jersey describe Judge Kavanaugh's nomination as a great moral struggle in which there are just two camps. You're either complicit in the evil or you're fighting against it. More recently, we've heard the junior senator from Hawaii argue that her personal disagreement with Judge Kavanaugh's judicial philosophy meant, now listen to this, he deserved less of a presumption of innocence when it came to allegations of misconduct. If you disagree with her, you're not entitled to the presumption of innocence when it comes to allegations of misconduct. That's from a member of the Judiciary Committee? That's the definition of due process? Apparently you get due process only if you agree with her. And even more recently, we saw the junior senator from Rhode Island hold forth with great confidence, offering his expert interpretations of goofy jokes in high school yearbooks from the early 1980s. That was incredibly enlightening. Innocent jokes? Beer drinking references? Oh, no. Our colleague was quite positive there must be some other hidden or sinister meanings at play. Until, of course, a number of Judge Kavanaugh's classmates set him straight earlier this week. So stop and consider these snapshots. The absurdity, the indignity. This is our approach to confirming a Supreme Court justice. This is the Senate's contribution to public discourse? Before the ink had dried on Justice Kennedy's retirement, our Democratic colleagues made it perfectly clear what this process would be about: delay, obstruct, and resist. And before the ink had dried on Judge Kavanaugh's nomination, colleagues across the aisle, including Democratic members of the Judiciary Committee, were racing to announce they had made up their minds and were totally opposed to his confirmation. Mere hours after Judge Kavanaugh was nominated, my friend, the Democratic leader, promised, quote, "I will oppose him with everything I've got," he said, hours after he was nominated. It was thus abundantly clear that his number one political goal was to defeat the nomination by any means necessary. It was right there from the beginning, Madam President. A clear declaration, plain as day, nothing could get most Democrats to consider this nominee with an open mind. It would be delaying tactics, obstruction, and so-called resistance until the final vote was called. For a few weeks, their efforts played out along lines that sadly have become somewhat ordinary around here. There were excuses for delay. Those fell flat. There were gross distortions of Judge Kavanaugh's record that were batted down by outside fact checkers. And there were all the usual phony apocalyptic pronouncements that are shouted whenever a Republican president dares to nominate a Supreme Court justice. Happened every time. Hostile to women, hostile to vulnerable people, hostile to workers. Same old tricks, same old playbook. But here was the problem. The old plays weren't working. The distortions were being literally drowned out by the facts. Senators received and reviewed more pages of background materials on Judge Kavanaugh's nomination than for every previous Supreme Court nomination combined. We read Judge Kavanaugh's 12-year record of judicial rulings from our nation's second highest court, 300+ opinions. We heard sworn testimony, written accounts from hundreds of character witnesses from all stages of Judge Kavanaugh's life and career. And the picture painted by these facts was nothing like the caricature. Nothing like the caricature. So it was clear, Madam President, the old tactics weren't working. Wasn't going to get the job done. The resistance demanded more. Try something new, they said. Well, we all know what happened next. Uncorroborated allegations of the most sensitive, most serious sort were quickly sharpened into political weapons. One such allegation, shared by Dr. Ford in confidence with the Democratic side of the Judiciary Committee, somehow, mysteriously, found its way into the press. Well, Chairman Grassley immediately set out on a sober, focused search for the truth. The committee collected testimony, organized a new hearing, and most recently asked for the supplemental FBI background investigation, Judge Kavanaugh's seventh FBI investigation. By any fair standard, the facts, the actual facts, proved to be straightforward. No corroborating evidence, none, was produced to support any of the allegations leveled against Judge Kavanaugh. No corroborating evidence from the FBI inquiry or from anywhere else. Nothing. Well, that wasn't enough for our Democratic colleagues, of course. The facts were not exactly the point. After all, we sort of get it by now. When the very FBI investigation for which they'd been clamoring turned up no new evidence, the Democrats moved the goalposts yet again. I believe the latest story is that the whole investigation is invalid. Now listen to this, because individuals who had only recently been told secondhand or thirdhand about nearly 40-year-old allegations weren't treated as essential witnesses. Let me say that again. The latest story is that the whole investigation is invalid because individuals who had only recently been told secondhand or thirdhand about nearly 40-year-old allegations weren't treated as essential witnesses. Never mind that they didn't actually witness anything. They didn't witness anything. So let's be clear, Madam President, these are not witnesses. These are people supposedly in possession of hearsay that they first heard 35 years after the supposed fact. What nonsense. The people whom Dr. Ford claimed were witnesses, they have spoken with the FBI. We know that because they, through their attorneys, put out public statements saying so. And what we know now is what we knew at this time a week ago. There is absolutely no corroborating evidence for these allegations. Same thing we heard a week ago. If they were, you bet we'd have heard about it, but there isn't. So notwithstanding that, Madam President, the leak of Dr. Ford's letter in violation of her privacy and against her wishes opened the floodgates. The feeding frenzy was full on. The weaponization of her letter by the left led to a torrent of other equally uncorroborated allegations. They were dumped on Judge Kavanaugh and his family. And breathlessly, the media seized on them. The more outlandish, the better. Americans were informed that Judge Kavanaugh masterminded violent drug gangs as a young teenager until that accuser walked her story back. We were informed that Judge Kavanaugh beat someone up on a boat in a Rhode Island harbor until that accuser totally recanted. We heard another tall tale of physical assault until that account was thoroughly debunked by a sitting federal judge. Oh, and yes, we were informed that juvenile jokes in his high school yearbook were actually sinister, secret references. All the Keystone cops were on the case. Keystone cops were on the case, Madam President. And Senate Democrats cheered them on. They read parts of this uncorroborated, unbelievable mudslide into the Senate record. They cited them in an official letter demanding that Judge Kavanaugh's nomination be withdrawn. Were they true? Well, of course, that was quite beside the point. Quite beside the point. So long as they were convenient. Every effort was made to ensure that the fact-free verdict of the mob and the media would win out over the actual evidence. Make sure the mob prevails. But the uncorroborated mud and the partisan noise and the physical intimidation of members here in the Senate will not have the final say around here. The Senate will have the final say. So, Madam President, we're almost at the end of the runway. The crosswinds of anger and fear and partisanship have blown strong these past weeks. They've harmed a good man and his family. They've tarnished the dignity of this institution. But all of it can end today. The time has come to vote. The Senate stands on the threshold of a golden opportunity. We have the opportunity to advance the nomination of an incredibly well-qualified and well-respected jurist to a post that demands such excellence. We have the opportunity to put Judge Brett Kavanaugh on the Supreme Court, where his distinguished service will make us and our nation proud for years to come. But we have the opportunity to do even more. Today, we can send a message to the American people that some core principles remain unfettered by the partisan passions of this moment. Facts matter. Fairness matters. The presumption of innocence is sacrosanct. The Senate has turned its back on these things before, Madam President, but never for long, and never without deep regret. This institution does not look back proudly on the era of Joseph McCarthy, nor on any of the other times when the politics of personal destruction poisoned its judgment. No, the Senate looks back on those things with shame and with a conviction that we cannot go down that road again. We know the Senate is better than this. We know the nation deserves better than this. By confirming Judge Brett Kavanaugh to the Supreme Court, this brilliant jurist will be charged with upholding the rule of law and honoring American justice. We must hold ourselves to that very same standard. We must seize the golden opportunity before us today to confirm a Supreme Court justice who will make us proud, and to reaffirm our own commitment to the justice that every single American deserves.
As a reminder to our guests in the galleries, expressions of approval or disapproval are not permitted in the Senate galleries. The clerk will report the motion to invoke cloture.
Cloture motion. We, the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, do hereby move to bring to a close debate on the nomination of Brett M. Kavanaugh to be an Associate Justice of the Supreme Court of the United States, signed by 17 senators.
Unanimous consent, the mandatory quorum call be waived.
Is there an objection? Without an objection. By unanimous consent, the mandatory quorum call has been waived. The question is it the sense of the Senate that debate on the nomination of Brett M. Kavanaugh of Maryland to be an Associate Justice of the Supreme Court shall be brought to a close? The yeas and nays are mandatory under the rule. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. No. Mr. Barrasso. Aye. Mr. Bennett. No. Mr. Blumenthal. Mr. Blunt. Aye. Mr. Booker. Mr. Bozeman. Aye. Mr. Brown. No. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. No. Mr. Carper. Mr. Casey. No. Mr. Cassidy. Aye. Ms. Collins. Mr. Coons. Mr. Corker. Aye. Mr. Cornyn. Aye. Ms. Cortez Masto. No. Mr. Cotton. Aye. Mr. Crapo. Aye. Mr. Cruz. Aye. Mr. Daines. Aye. Mr. Donnelly. Ms. Duckworth. Mr. Durbin. No. Mr. Enzi. Aye. Mrs. Ernst. Aye. Mrs. Feinstein. No. Mrs. Fisher. Aye. Mr. Flake. Aye. Mr. Gardner. Aye. Mrs. Gillibrand. No. Mr. Graham. Aye. Mr. Grassley. Aye. Ms. Harris. No. Ms. Hassan. Mr. Hatch. Aye. Mr. Heinrich. No. Ms. Heitkamp. Mr. Heller. Aye. Ms. Hirono. Mr. Hoven. Aye. Mrs. Hyde-Smith. Aye. Mr. Inhofe. Aye. Mr. Isaacson. Aye. Mr. Johnson. Mr. Jones. Mr. Kane. No. Mr. Kennedy. Aye. Mr. King. Ms. Klobuchar. No. Mr. Kyle. Aye. Mr. Lankford. Aye. Mr. Leahy. Mr. Lee. Mr. Manchin. Mr. Markey. No. Mrs. McCaskill, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Nelson, Mr. Paul, Mr. Perdue, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott, Mrs. Shaheen, Mr. Shelby, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young, Senators voting in the affirmative: Alexander, Barrasso, Blunt, Bozeman, Burr, Capito, Cassidy, Collins, Corker, Cornyn, Cotton, Crapo, Cruz, Daines, Enzi, Ernst, Fisher, Flake, Gardner, Graham, Grassley, Hatch, Heller, Hoeven, Hyde-Smith, Inhofe, Isaacson, Kennedy, Kyle, Lankford, McConnell, Moran, Paul, Perdue, Portman, Risch, Roberts, Rounds, Rubio, Sass, Scott, Shelby, Sullivan, Thune, Tillis, Toomey, Wicker, and Young. Mr. Manchin, aye. Senators voting in the negative: Baldwin, Bennett, Booker, Brown, Cantwell, Cardin, Casey, Coons, Cortez Masto, Duckworth, Durbin, Feinstein, Gillibrand, Harris, Heinrich, Kane, Klobuchar, Leahy, Markey, Merkley, Murkowski, Murphy, Murray, Nelson, Peters, Schatz, Smith, Stabenow, Tester, Udall, Warner, Warren, Whitehouse, and Wyden. Mr. Sanders, no. Mr. Lee, aye. Ms. Hassan, no. Mr. Jones, no. Mr. Johnson, aye. Mr. Schumer, no. Mr. Donnelly, no. Ms. Heitkamp, no. Mrs. McCaskill, no. Mr. Menendez, no. Mr. Reed, no. Mr. King, no. Mr. Van Hollen, no. Ms. Hirono, no. Mr. Blumenthal, no. Mrs. Shaheen? No. Mr. Carper?
Senator is not recorded.
I vote no.
Mr. Carper? No.
Are there any senators in the chamber who wish to change their vote? As a reminder to our guests in the galleries, expressions of approval or disapproval are not permitted in the Senate galleries. On this vote, the yeas are 51, the noes are 49. The motion is agreed to.
Madam President,
Senator from Texas.
Madam President, I'd ask unanimous consent that the quorum call be dispensed with.
Senate's not in a quorum call.
Thank you, Madam President.
Senators recognized.
Madam President, could we have order in the Senate, please?
Senate will be in order.
Madam President, as the world knows now, we just held a successful cloture vote on the nomination of Brett Kavanaugh to become the next Associate Justice on the United States Supreme Court. And I'm glad we were successful in closing off debate. We now know that under the Senate rules, 30 hours are available for senators to debate, and I'm sure there will be many senators who will be coming to the floor and offering their thoughts. But to my mind, what the Senate just voted for was to end the games, the character assassination, and the intimidation tactics that unfortunately have characterized so much of this confirmation process. Our vote today was important not only because it will allow us to move forward and conclude this confirmation process, but it was important because it showed that the United States Senate will not be intimidated. We will not be bullied by the screams of paid protesters and name-calling by the mob. We will not be complicit in the attempts to tarnish a good man's character, destroy his career, and further delay this confirmation process, a constitutional process of advice and consent. What has been particularly galling on the part of some of our colleagues over the last 24 hours is the fact that the FBI investigation that they called for, they are virtually ignoring, or in some cases disparaging. They called for that supplemental background investigation just last Friday. Let's all remember what our friend, the senior senator from Minnesota, said, for example, last weekend. She said, let's give this 1 week. Well, that's what we gave them. The junior senator from Delaware asked for the same period of time at the hearing, a 1 week long FBI investigation. So our colleagues got what they asked for, and unfortunately, since they had already decided to vote against the nomination, they must have been somewhat disappointed that the supplemental background investigation came up with no new information, no corroboration at all. Now, I actually think in some ways our colleagues who called for a 1 week delay have done us a favor, because every lead that could be followed has been followed and exhausted. And as the majority leader was saying earlier, in America, under our constitutional system, where we don't presume that you're guilty and require you to prove your innocence, and where we believe in due process of law, I think the FBI investigation was a useful way to demonstrate to the American people that none of these allegations that have been made against Judge Kavanaugh of sexual misconduct have been proven. It also, I think, gives us a chance to pivot from what has been a shameful and disgraceful confirmation process. If this is the new norm for the Senate, that somebody could be denied a confirmation based on an unproven allegation, I can't imagine people being willing to subject themselves to that in the future. And it would be a dark day for the Senate and for the United States and for our system of justice that believes in a fair process and a constitutional presumption of innocence. And when an allegation is made, that the person making that allegation actually has to come forward with some evidence. A number of senators, actually it was a bipartisan consensus, wanted the FBI to conduct a limited investigation into current credible allegations that were pending. They wanted the FBI to interview individuals like Mark Judge, who had already offered a sworn statement under penalty of felony, and others who may have had information that were identified by Dr. Ford as being present on the day that this alleged activity took place. There was no confirmation, there was no corroboration. In fact, there was a refutation. The people she said were there and could be witnesses, were witnesses to what happened, said, I have no knowledge of that. Dr. Ford's best friend, Leland Kaiser, said, I don't even know Brett Kavanaugh. I've never met him. Well, we've all had an opportunity to read the confidential report. We've seen who was interviewed, what they were asked, and any doubts that people may have had should now have been put to rest by what the contents reveal. These fantasies about Judge Kavanaugh being some sort of serial high school or college predator have been exposed as only that, myths, not based on fact. There's no reliable evidence whatsoever to support any of these baseless allegations against Judge Kavanaugh. But as we know, this wasn't exactly designed to be a truth-finding process. This wasn't a search for the truth. Our colleagues across the aisle had already made up their mind a long time ago, some even before Judge Kavanaugh had been nominated. This was more of a, as the majority leader said earlier today, not a search for the truth, but a search and destroy mission. And obviously, as they continue to move the goalposts, calling for more delays, more investigations, there's been 7 background investigations by the FBI of Judge Kavanaugh during his public service. The FBI has talked to more than 150 witnesses. Don't you think if there were anything to these outrageous allegations that some of that would have come up at some point in the 7 FBI background investigations that have been conducted? But our colleagues across the aisle continue to resist putting a definitive end to this process, and unfortunately, caring little, if any, about the reputation of somebody who has demonstrated his outstanding qualifications and his commitment to public service. I think some of these attacks have become exhausted, politically exhausted, frankly. Our colleagues don't seem to realize what they have unleashed. When senators get coat hangers mailed to their home, protesters, paid protesters, show up on their doorstep or at their office, or are accosted in the halls of the United States Congress. Paid protesters who reportedly, once they get arrested, actually make more money from their funders than they do if they don't get arrested. That is what has been unleashed. Chairman Grassley called it mob rule. That's exactly right. Where the Judiciary Committee during the first confirmation hearing for Judge Kavanaugh, where senators said, I'm breaking the rules. I'm releasing committee confidential information I know the rules prohibit me from doing. And they don't care. If there are no rules and there are no norms, and if we don't have enough respect for this institution and the people whose lives we touch, this is what gets unleashed. I feel badly for Dr. Ford in particular. She wanted none of this 3-ring circus. She sent a letter to the ranking member and asked that her identity remain confidential, only to find after the first confirmation hearing that it was leaked to the press. And then the press came to talk to her, and I guess she figured she had nothing else, no other recourse but to actually tell her story to the press once her wishes were violated. She didn't consent to that. She didn't authorize the release of that confidential letter to the press, but that's what happened. When we gave her an opportunity to have a bipartisan professional investigation staff come out to California and interview her confidentially, she said, nobody explained to me that was an option. Well, the lawyers that the ranking member referred her to apparently didn't even tell their own client that she had the opportunity to avoid this 3-ring circus and the embarrassment associated with it by doing something confidentially. That's how the Judiciary Committee ordinarily operates. When allegations are made, they're investigated by committee staff or by the FBI actually by both. But that didn't happen here until after this mob rule unleashed what we've seen here in the last few weeks. We know that when Dr. Ford sent her letter to the ranking member, that it wasn't shared with the FBI initially, wasn't shared with Judiciary Committee investigators, it wasn't shared with the committee itself in a closed-door session, which followed the open session where Judge Kavanaugh was asked about other personal matters that came up during the course of the background investigation. The ranking member didn't even attend that closed-door session, nor did anybody mention it to the judge when he went to talk to some 60-plus members of the Senate one-on-one. The ranking member, when she had that one-on-one meeting with Judge Kavanaugh, she said nothing to him about the allegations. She could have asked him about the allegation generally without revealing the identity of Dr. Ford. We know at that point she'd already talked to Dr. Ford and recommended partisan lawyers. We know that those lawyers arranged for a polygraph examination to be administered. Other preparations were being made, plans were being hatched. And our colleague from California said nothing. I really think that Dr. Ford has been treated terribly by this ambush, by this hiding evidence and allegations that could have been investigated, should have been investigated in a more dignified and appropriate sort of way. Once Dr. Ford was identified, in consultation with colleagues, both Republicans and Democrats, we decided that Dr. Ford should be given an opportunity to tell her side of the story. Unfortunately, we weren't able to mitigate or reverse a lot of the awful circumstances under which she found herself because of what had already been unleashed, but we did our best. We tried to do whatever we could to accommodate her. As I said, investigators offered to come to California. We brought in an experienced sexual crimes investigating attorney to ask questions in a respectful and sort of way to elicit as much information as we possibly could get about her claim, even though it was 35 years old. Throughout the hearing, we listened to Dr. Ford, and we tried to understand what she was telling us. We took her allegations seriously and treated her the same way we would want our wives or our daughters treated if they found themselves under similar circumstances. But we know what, at the end of the day, there's no other witness who could corroborate or confirm what she said, even the ones that she identified as having been present. This is not about believing women or believing men. It's not a zero-sum game. As the junior senator from Nebraska said the other day, it's not about being for the Me Too movement or against it, but who could be against it? I hope there's some good that comes out of this disgraceful display. One of the things that might be good be that more women would feel confident to come forward and tell their story to the appropriate authorities and produce the sort of information that would be necessary to make a criminal case, to investigate the case, to charge the case, to try the case, and to convict people who commit sexual offenses. I hope there's some good that comes out of this. There's also maybe some legislation that we could work together on to try to heal the wounds that have been caused by this abominable process. I've worked a lot with colleagues here to pass anti-human trafficking legislation, to end the rape kit backlog, and to do other things to try to help victims. And I think maybe, just maybe, putting our heads together, talking with each other, working in good faith, we could come up with some legislative response that might find some good out of this terrible situation. The other thing about these allegations made against Judge Kavanaugh is they are completely out of character. We know he's been a circuit court judge for 12 years, authored more than 300 opinions, clerked for Anthony Kennedy on the Supreme Court, worked at the White House as a lawyer and staff secretary for the president. He's taught at Harvard. He was hired by now Justice Elena Kagan to teach at Harvard, as well as teaching at Georgetown and Yale. And by all accounts, every account of anyone with personal knowledge of Judge Kavanaugh's character and treatment of women, they all say he treated women with respect. It's not just conservatives that sing his praises. A liberal law school professor at Yale called Judge Kavanaugh's selection the president's finest hour, his classiest move. The same professor complimented Judge Kavanaugh's studiousness and said he's already shown flashes of greatness. Lisa Blatt, a self-described liberal feminist lawyer who's argued numerous cases before the U.S. Supreme Court, has said Judge Kavanaugh is supremely qualified. That echoes what the American Bar Association, the gold standard for some of our colleagues when it comes to judicial nominees. The American Bar Association has said that Judge Kavanaugh is unanimously well qualified, and that goes for his temperament as well. So I believe this nominee is about as good as it gets. July 10th, the day after Judge Kavanaugh was nominated, I said that my Republican colleagues and I won't back down from this all-out assault on this nominee. But never in my wildest dreams could I have imagined that this fight would devolve into the mob rule that we've seen. Senators and staffs taunted, threatened, millions of dollars spent in advertising, in paying protesters to show up on senators' front lawns, harass them at restaurants, and attack them in the halls of the Congress. I never imagined this would get this bad, where senators would say, "I'm breaking the rules," and dare anybody to do anything about it. This has turned into the kind of nasty and venomous politics that I hoped never to experience. This also has demonstrated the dark underbelly of Washington, D.C., where power is so important to some people, they will do anything to get it. They will destroy you. They will tarnish your good name. They will condone threats on family members, including children. They will harass you. This has really been disgusting. I'm an optimist, Madam President, so I don't believe that this is our fate. I don't believe we're condemned to work in a Senate and live in a country where this kind of activity is condoned or ignored. I actually think by defeating Judge Kavanaugh's nomination, we would be signaling that this is somehow the new normal. We would be setting a precedent that, yeah, that kind of stuff works, so let's try it again. And I'm not just saying one party or the other. The day after Judge Kavanaugh was nominated, I also said, we will defend the record of Judge Kavanaugh, who is a thoughtful public servant, against deliberate attempts to denigrate him. I stand by that statement, and we have defended him, but not just defended him, but defended the Constitution, fundamental notions of fairness and fair play that are reflected in our commitment to due process of law and the rights of somebody accused of a crime, which Judge Kavanaugh has been accused of on multiple occasions. Even as the mud has been slung on all of us, even as insults have been hurled against this nominee and his family has faced ridicule over atrocious exploits that never even happened, at least I think we can be proud of the fact we've tried to defend the Constitution, this institution of the Senate, and push back with everything we have against mob rule. Unfortunately, those who wanted to take down this nominee have viewed Judge Kavanaugh as a sacrificial lamb in some sort of vengeance campaign, but thankfully, they've now failed to stop his nomination from going forward. This nomination is no longer simply about Judge Kavanaugh and the current vacancy on the Supreme Court. It's also about the principles we must stand up for and defend. It's about validating public service and decades of honorable conduct. It's not about forgetting all that a man has done, all that he is, and all that he's worked for at the drop of a hat, based on unsubstantiated, uncorroborated allegations. It is about standing firm in the turbulent political winds. And if I think about any institution in this country, I think the Senate ought to be the place where that standing firm against the turbulent political winds occurs. We all had a chance to read the FBI report, which failed to corroborate Dr. Ford's allegations. And then today we did exactly what we needed to do, which is to vote. To stop the circus, stop the hijinks, stop the character assassination, and vote. So I'm glad our colleagues decided to close off debate now as this 30-hour post-cloture period ensues. I look forward to concluding the confirmation process and confirming Judge Kavanaugh to be the next Associate Justice on the United States Supreme Court.
Madam President.
Senator from Illinois.
Madam President, I'd like to respond to my colleague from Texas, at least one or two aspects of what he has said. He has characterized the opposition to Judge Kavanaugh as mob rule. I don't think that's a fair characterization. The opposition to Judge Kavanaugh comes at many different levels. My colleagues on both sides of the aisle, I believe, have looked at this nomination seriously, and they've come to opposite positions. I don't believe we are influenced, frightened, or in any way moved by mob rule. I just don't get it. Now, have I seen conduct by people who feel strongly about this issue that I think is untoward and really should not be condoned? Of course. Do I believe that people should have their freedom of speech limited or stifled? No, I don't. Even if it's something I don't want to hear, people have a right to speak. Of course, I will never condone violence or any physical activities against anyone, including members of Congress. And some people have either come close to that line or stepped over it. I don't defend that in any way, shape, or form. But if we are truly committed to the Constitution we've sworn to uphold and defend, that First Amendment creates opportunities for American citizens which others around the world long for and never see once in their lives. Part of that is freedom of speech. Part of that is the right to petition your government. So if some have stepped over the line, I won't defend them when it comes to violent conduct. But in expressing their point of view with a sign or a march or even a chant, I have to say that is part of our constitutional birthright, thank goodness, in the United States of America. Last week I saw Dr. Christine Blasey Ford for the first time. I'd heard her name for a week or more. I'd seen one photo of her in sunglasses. I'd never seen her or heard her speak. She came forward at great risk to herself and to her family after having been dislocated from her 2 different homes with her kids. And she came here to face the Senate Judiciary Committee and the nation and to speak under oath. She had absolutely nothing to gain by coming forward. She did it, as she said, out of a sense of civic duty. She wanted to